The next important selected leading case is that of 12 number and which is Hannis versus Harrod. The case was decided by the Court of Appeal in 1936 was the first authoritative decision on the law with regard to position of rescuers, and this has materially affected the doctrine of Volenti non-fit injuria. It laid down that in rescue cases it was immaterial whether the plaintiff actually act deliberately from a sense of moral duty. In such a case, under compulsion of the duty or on the impulse for the exercise in such a case, no choice in acting as he did. In this, the plaintiff, a police constable, was on duty inside a police station in a street in which were a large number of people, including children. Seeing the defendants run away, horses with a van attached coming down the street, he rushed out and eventually stopped them, sustaining injuries in consequence. In respect of which he claimed damages, it was held that the defendant's servant was guilty of negligence in leaving the horses unattended in a busy street, and that as the defendant master ought to have contemplated that someone might attempt to stop the horses in an endeavor to prevent injury to life and limb, and as the police were under a general duty to intervene to protect life and property, the act and injuries to the plaintiff were the natural and probable consequences of the defendant's negligence. And now we'll go to another important selected leading case, and that is number 13 relating to Davis versus Mann. The case is based on the doctrine of contributory negligence. Contributory negligence of the plaintiff is no defense if the defendant had a later opportunity than the plaintiff of avoiding the accident by reasonable care. In this case, the plaintiff had negligently left his donkey with its legs tied in a narrow lane, and the defendant subsequently coming with his wagon at a smart rate negligently ran over the donkey. It was held that the plaintiff was entitled to his remedy, notwithstanding any negligence on his part, in as much as the accident might have been avoided by the exercise of ordinary care on the part of the driver by going at such pace as would be likely to avoid the mischief. Although the ass may have been wrongfully there, still the defendant was to bound to go along the road at such a pace as would be likely to avoid the mischief. Were this not so, a man may justify the driving over goods left on a public highway, or even over a man lying asleep there, or purposely running against a carriage going on the wrong side of the road. And now we'll go to the next important selected leading case, which is known as Six Carpenters case, or as the very case is between Box versus Newman. The case also known as Box versus Newman, or Six Carpenters, as entered a tavern and did there buy and drank a quart of wine and paid for the same. Then they gave a further order, another quart of wine and a penny worth of bread, amounting to 8 decent. This order was also fulfilled, but for the second supply the men refused to pay. The question was whether this non-payment made original entry into the tavern unlawful. The court held that the men did not trespass ab initio because there was a mere non-feasance in refusing to pay. In this case, 3 points were laid down. One is that if a man abuses an authority given to him by law to become trespasser ab initio, and the second point raised that in an action of trespass, if the authority be pleaded, the subsequent abuse may be repaired. And the third point raised was that a mere nonfeasance does not amount to such an abuse as renders a man trespassers ab initio. And now we'll go to an Indian important selected leading case, and that is state of Rajasthan versus Vidyavati. So in this case, the driver of a jeep owned and maintained by the state of Rajasthan for the official use of the collector of a district drove it rashly and negligently while bringing it back from the workshop after repairs and knocked down a pedestrian and finally injured him. Supreme Court held that the state was liable for the Tortures Act like any other employer. In the case, their lordship observed, viewed from first principle, there can be no difficulty in holding that the state should be as much liable for tort in respect of a tortious act committed by its servant within the scope of his employment, but wholly disassociated from the sovereign powers and functions as any other employer. The mere fact that the car was being maintained for the use of the collector in the discharge of his official duties is not sufficient to take the case out of the category of cases where vicarious liability of the employer could arise, even though the car was not being used at the time of the occurrence for any purpose of the state which would fall under sovereign functions of the state. So the state was held liable. So in our next video, that is the upcoming video, will discuss the rest 5 important selected leading cases